today. The state did provide to me certain documents and evidence to review. One of those was what purports to be a grand jury summons that was improperly issued because it was issued under the 2024 CR 1237 cause number. A grand jury subpoena is not a proper subpoena by which to.
Excuse me, I'm just one moment. Off the record for a second. Norma, Mr. Thompson, do you live out of state or out of county? Austin? All right, Norma, he can appear by Zoom. And since I'm allowing you to appear by Zoom, or even if you have to appear in person, court starts at 9 a.m. Do you understand? All right, so they'll have you sign the reset form and it'll note that you can appear by Zoom. All right, we're back on the record. You may continue. What was the number for the grand jury summons?
2024 CR 1237. So this grand jury summons ordered her to appear before the grand jury on a post-conviction, a case that's already been adjudicated and is now on probation, which is improper, and for her to appear on the 22nd day of January 2026 before a grand jury. That was where she was served with the subpoena for this case. So they used a subterfuge to subpoena my client for this. Then when she was interviewed by the district attorney, she was threatened with going before the grand jury and being thrown in jail if she didn't want to talk to the district attorney. I know that because that's in the notes that were provided to me from the district attorney, who is not these fine prosecutors who are here today, Judge. She was also told when she asked if she could have a lawyer that she didn't need a lawyer, she didn't need to consult with a lawyer, and that she'd done nothing wrong. Why would she need a lawyer? But then at the end of the conversation, they were also talking about her being incarcerated if she refused to talk to them. I would also like the court to take judicial notice that my client has filed an affidavit of non-prosecution in this case. She does not wish to testify. The subpoena ordering her to appear today was obtained by fraud because a grand jury subpoena should not have been used to bring her in to speak to the prosecutors. That was an attempt, I believe, to avoid discovery of the defense because grand jury subpoenas are secret. Had they subpoenaed her properly in this case, the defense would have known that she was coming in to talk and they would have had to turn over those notes. I also feel like they have threatened her with perjury. They have threatened her with incarceration if she refuses to testify. And because of that, and because I would have to trust this district attorney's office to know what the truth is and what the truth is not, I'm going to advise her to plead the Fifth Amendment if she does take the stand, because I don't know if they would later charge her with perjury if she said something they didn't agree with. And again, I'm not speaking to these two prosecutors directly, but to the administration that is driving this train.
All right, so the record is clear. Defense counsel is not speaking of any actions that were done by the prosecutors who are physically in this courtroom. That's correct?
Yes, Your Honor.
And that includes Mr. Moray?
Yes.
All right. So let's start with one, the grand jury summons in 2024 CR 1437. Defense says that summons was improper. Mr. Moray, are you going to do the argument, or who's doing the argument with regards to that?
I'll go ahead and do that, Judge. So regarding the grand jury subpoena, I've reviewed it, and just so the record is clear, I'm not the prosecutor that one ever met with the witness prior to today, and two, I'm not the prosecutor that issued that grand jury subpoena. However, I don't believe that Ms. Chacon has standing to contest that subpoena. The court is able to review it. It was issued in the case that we're here for today. That is an indicted case, so I'm not disputing that. However, if we're looking at the case, what has been turned over to both parties is that an investigator from the district attorney's office went to the residence of Emily Pruitt and served her with this grand jury subpoena. And so it's kind of like an inevitable doctrine of like, we had her address, we're able to secure her and serve her with a subpoena, and that's standard routine in cases that are prosecuted by this office. Many witnesses are issued subpoenas to appear, and so she has been subpoenaed for this cause, under this cause number, with the correct subpoena ducis tecum to appear today to give testimony. And so I don't believe that Ms. Chacon has standing to challenge that. She wasn't representing her at the time. And I think that we would need additional testimony from the witness for the court to determine the allegations, I guess, that are set there for.
So I want the record to be clear, and I want my understanding to be clear. So was there first a grand jury subpoena? And then while I'm assuming, and if my assumptions are incorrect, let me know. I'm assuming that the witness appeared for the grand jury subpoena, under the grand jury subpoena?
Judge, so it's my understanding, and I'm gonna have my co-counsel print out the subpoenas, but it's my understanding that at the time that the DA investigator went to serve the witness, Emily Prue, that she was served with subpoena ducis tecum and a grand jury summons.
Okay.
And I'm unsure of the date of the subpoena ducis tecum. They'll have to look it up. I asked your coordinator this morning, she couldn't find it.
So this is what the court wants to know. Number one, was she issued with a grand jury subpoena? And then while she was honoring the grand jury subpoena, was she then given another subpoena? That's what I want to know.
Judge, if I could just have leave from court because my computer's not cooperating with me. and I
Yes.
have to print out the
Okay,
subpoenas of those issued, please.
sure. And then after I receive evidence with regards to those questions, then we'll move on to the allegations of the threat. And what I can tell both parties, the allegation of the threat, I'm gonna need to hear from the witness with regards to any allegations of threat.
Says they threaten.
Judge, and I think there's enough in the document that was given to us by the prosecutor that conducted the interview that I think clearly shows that.
All right, well, if y'all want to admit that for purposes of this hearing, for me to decide whether or not your objection should be sustained or not, I need to see that trial tomorrow. So, but I did volunteer somebody else who's here, so you'll find out about that. All right, we're back on the record. Is there anything you wish to add to your argument?
Yes, Judge, I was under the impression from viewing the documents earlier that the subpoena was issued on the date that my client was brought in under the grand jury subpoena. What has actually come to light is there's no return of service date on the grand jury subpoena. So I have no idea what date that was issued to her, but she did show up and talk to the prosecutor on the 22nd of January because she received this subpoena.
Okay,
The return on the trial subpoena or the MTR subpoena has the 20th of January as its date. So that was, I guess, 2 days before she had to come into the grand jury. Either way, I'm going to advise this witness to plead the Fifth Amendment if she is forced to testify. In no other case that I've heard, other than a property crime case, does the DA's office want to proceed with an AMP. It's not a domestic violence case, except for the fact that this is a media case that has caused all sorts of embarrassment to the office, but it is wrecking this girl and she doesn't want to be here. I don't know how to mark this, but I have the notes that were provided by the prosecutor who interviewed her under the illegal grand jury subpoena, Melissa Alman, and it lists out that she told her that she could be incarcerated if she wouldn't answer her questions, which I think is enough of a threat, Judge. But if everybody's seen this, do you mind if I?
okay, I think all parties agree that a witness cannot be threatened with incarceration.
That's correct, Judge, and my reading of it, I guess the court would need to do an in-camera inspection, or I don't have any objection to it being made part of the record, but that's not exactly what it states in there.
All right,
States that the witness asked what the repercussions would be for her failing to appear in accordance with the court order, and she was advised that if the judge saw fit, that she could be arrested and brought to court, and that is the law.
all right. So let's mark that as an exhibit so the court can review it. And
Cindy has that.
we'll mark it with a W for witness. And you can call it W1.
May I approach?
Yes. Any objections to the court, reviewing, W1? For purposes of this
No,
hearing?
Judge, I don't have any, but just. Can we just all label with the same, so I had Q, or motion to quash, but
I'm sorry?
Court is okay with it being labeled.
What did you want it labeled as?
As Q,
All right, we can label it as Q,
Oh, that's fine. I don't care.
Q1.
correct.
All right, so then, Q1 for the record, Ms. Chacon, what is Q1?
Q1 is the notes that were provided to myself, the prosecutors and the defense counsel from the prosecutor's interview of my client. I've taken many witnesses before the grand jury, Judge, and I've had those conversations with witnesses about what repercussions happen if they don't want to answer questions. That's not what I think this is. The girl asked for a lawyer. She was told she didn't need a lawyer. Then she was told that she might have, if you're not committing a crime, why would you need a lawyer? But then it's very strongly implied that if she's not telling the truth, she can be in trouble. She asked what would happen if she had to go before the grand jury. We're talking about a very young woman who's told she's going to go down and see a judge and maybe get arrested if she doesn't want to answer questions. I just don't think that's how you go about it. And I think that they knew they were pushing her. And today, to appear today, she knew she could get arrested if she didn't come. I mean, this is a very coercive environment that they're asking to put this witness on. And
All right, the court is going to review Q1 and then I can hear arguments.
Judge, and then just for the record, for the state side, we have CDT exhibits Q1 and Q2, which are copies of the subpoena testificum that was served on the witness on January 20th of 2026, and then the grand jury summons is Q2 that was served on the same day, however, it's unexecuted. I have a copy of that.
All right, any objections? Defense? Any
No,
objections to the court reviewing those documents?
No, Judge.
All right, and it states Q1 and
Q2.
Q2 will be admitted without objection for purposes of this hearing.
Out of you and George.
I plead the fifth.
And David Torres, is he also on your iPad?
Judge, I'm still gonna object as to relevance, what she's doing in her,
It's in evidence.
All right, well,
those are
Can I-
statements that the defendant made, though, what she's doing in her free time that he's.
may I see the exhibits, please?
May I approach?
Yes.
I'll move on, Judge, just to get this thing rolling. Now, that particular night, Eric thought the baby was with you, right? At least earlier in the day, correct?
Yes.
That'll be overruled.
And then Eric, according to your iPad location, would, it would be safe for him to assume if you were with the baby and your iPad said you were at home, that he would think you were at home, correct?
Elaborate?
Well, on this particular night, Eric knew he didn't know your mother had the baby at that point, right?
No,
You hadn't told him that was your plan, correct?
no,
In fact, no, that's not correct?
it's correct.
Oh, that is correct, okay. And then in fact, as I understand it, you had originally talked to him during the day and he thought you were going to work later. You actually went in earlier than you were supposed to, or something like that, is that right?
Yeah.
Okay. So at some point, Eric is trying to look for you. And he sees that you're at your apartment. And then he calls you a couple of times. Do you answer any of those calls?
No,
Okay. And can you see if he thought you were home with the baby and why you didn't answer, why that might get him concerned?
sure.
Okay, I mean, he cares about his daughter, correct? I mean, I don't want to, does he participate in her life?
To an extent,
Okay, and does his family participate in her life?
yes.
Now, talk about the family. You lived with Eric and his family before this apartment, is that correct?
Yeah.
And even sometimes during the apartment, you still stayed with Eric and his family.
What you just watched is not something you see every day in a courtroom. Before the state's key witness ever took the stand, her own court-appointed attorney stood in front of that judge and made a series of extraordinary allegations against the district attorney's office. Not the prosecutors standing in that courtroom. She was specific about that, but the administration above them. According to that attorney, a young woman, the named victim in a pending criminal case, was served with a grand jury subpoena under the wrong case number, brought to the DA's office, asked to talk without being allowed to get a lawyer, told by an assistant district attorney that she did not need one, and then threatened with going before a grand jury and potentially being jailed if she refused to cooperate. The judge did not dismiss those concerns, and she raised her own, pointing out on the record that a subpoena compels a witness to appear in court or before a grand jury, not in a prosecutor's office. "I've seen this before," she said, and then she read ADA Albin's own case notes out loud in open court, line by line. The court ruled the witness had to testify, but any statement she made during that office interview was thrown out, inadmissible, a partial win for each side. And then Emily took the stand, reluctantly, under compulsion. And when defense counsel asked her directly whether the DA's office had threatened to arrest her, if she didn't answer questions, she looked at the court and said yes. The law gives the state compulsory process. It gives prosecutors real power over witnesses, but it also requires that power to be used with precision and restraint. Whether it was here is a question this transcript raises without fully answering. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.